Okay, hello. Nandito na naman po ang inyong Lola Ray para sa isa na namang edisyon ng layman's terms, okay? Nandito pa rin po tayo para i-discuss ang civil procedure o yung procedure para sa mga civil cases. Okay. So, tapos na po tayo sa Rule 1 hanggang 20. Susubukan nating i-discuss yung Rule 21 to 30 para sa mga katulad ko na ordinaryo nating mga kababayan. Sama-sama po natin itong pag-aralan. Okay, basahin natin at subukan nating ipaliwanag. Okay, Rule 1. Rule 1, Rule 21, Subpoena. Sabi rito, ang subpoena and subpoena duces tecum. So let us explain, no? Subpoena is a process directed to a person requiring him or her to attend and to testify at the hearing or the trial of an action or at any investigation conducted by competent authority or for the taking of his or her deposition. It may also require him or her to bring with him or her any books, documents, or other things under his or her control, in which case it is called as subpoena duces tecum. O pag inuutusan ka ng korte na magdala ka ng mga dokumento, yun ay subpoena duces tecum. O kadalasan alam nating mga ordinaryong tao na mga hindi naman abogado yung subpoena. Yan yung pinapatawag tayo sa korte, di ba? Pinapatawag tayo. Pag pinatawag naman tayo para magpadala ng dokumento, yun yung subpoena duces tecum, di ba? Section 2, by whom issued. Kanino ba ito ini-issue? Sabi rito, the subpoena may be issued by A, the court before whom the witness is required to attend. B, the court of the place where the deposition is to be taken. C, the officer or body authorized by law to do so in connection with investigations conducted by said officer or body, or any justice of the Supreme Court or the Court of Appeals in any case or investigation pending within the Philippines. Yan, malinaw naman yan, ha? When an application daw for a subpoena to a prisoner is made, the judge or officer shall examine and study carefully such application to determine whether the same is made for a valid purpose. So, yun po ang subpoena, mga kapatid. Wow! Aha, grabe naman. Nag-tumbling pa ang aking device, ha? Okay. Okay, ano nang susunod? Eto. No prisoner, sabi niya. Sabi nung rules of court, no prisoner daw sentenced to death, reclusion perpetua or life imprisonment and who is confined in any penal institution shall be brought outside the penal institution for appearance or attendance in any court unless authorized by Supreme Court. So sabi nila, ha, kung ang sentensya mo ay kamatayan or reclusion perpetua or life imprisonment, di ka raw pwedeng palabasin doon unless pinayagan ka ng Supreme Court. Section 3, Form and Contents. Sabi niya rito, a subpoena shall state the name of the court and the title of the action or investigation shall be directed to the person whose attendance is required, and in the case of a subpoena duces tecum, it shall also contain a reasonable description of the books, documents, or things demanded which must appear to the court prima facie relevant. Ayan, ha? Ano ba ibig sabihin ng prima facie? Para lang sa ating kaalaman, no? Yung mga abogado, syempre, saka yung mga nagtatrabaho sa korte, alam na alam ito. Pero subukan nating alamin, ano bang ibig sabihin ng prima facie? Sabi rito, based on the first impression. Ayan, yun ang meaning niya. Accepted as correct until proved otherwise. Prima facie. Yun, ha. Sa unang enkwentro o sa unang pagtingin, yun ang ibig sabihin ng prima facie, no? Para lang sa kaalaman natin, ha? Sama-sama tayo, hindi man tayo mga law students. Ako, hindi naman na ako law student. Hindi man tayo abogado. Pero at least may idea tayo. So ano bang rules yung nag-govern sa mga trials, di ba? Mga ganyan-ganyan. Section 4. Quashing a subpoena. The court may quash a subpoena ducis tecum upon motion promptly made and in any event at or before the time specified therein if it is unreasonable and oppressive, or the relevancy of the books, documents, or things does not appear, or if the person in whose behalf the subpoena is issued fails to advance the reasonable cost of the production thereof. Ay, yun yung sabi nila. Yung korte daw ang pwedeng mag-quash ng subpoena. The court may quash a subpoena ad testificandum on the ground that the witness is not bound thereby. In either case, the subpoena may be quashed on the ground that the witness fees and kilometrage allowed by these rules were not tendered when the subpoena was served. Section 5, Subpoena for Depositions. Proof of service of a notice to take a deposition as provided in Section 15 and 25 of Rule 23 shall constitute sufficient authorization for the issuance of subpoenas for the persons named in said notice by the clerk of court of the place in which the deposition is to be taken. The clerk shall not, however, issue a subpoena ducis tecum to any such person without an order of the court. No, yun ha. Wala kayong libro, papakinggan nyo lang to, no? Lalo na sa mga ordinary mamamayan na katulad natin, hindi naman tayo namimili ng libro. Ako, nung nag-aaral ako ng batas, hindi naman ako namimili ng libro. Yung mga photocopies, nabaha, wala ka ng kopya. Eto, nagbabasa na lang tayo sa internet, no? O, kung ayaw magbasa, pakinggan nyo na lang to, no? Section 6, Service. Service of a subpoena shall be made in the same manner as personal or substituted service of summons. Parehas lang. The original shall be exhibited and a copy thereof delivered to the person on whom it is served. The service must be made so as to allow the witness a reasonable time for preparation and travel to the place of attendance. So parang ako nalito na ako, ano kaibahan ng subpoena, di ba? Doon sa ibang yung ibang summon, di ba? Isa rin siyang uri po ng summon, yung subpoena. Yun nga, dinefine natin kanina. Sino pinapatawag ka para kuhanan ka ng deposition o ng salaysay, o di naman pinagdadala ka ng dokumento, or tinatawag ka para tumestigo o para magsalaysay ng iyong nalalaman. Subpoena ad testificandum. Costs for court attendance and the production of documents and other materials subject of the subpoena shall be tendered or charged accordingly. Ayan ha. Section 7, Personal Appearance in Court. A person present in court before a judicial officer may be required to testify as if he or she were in attendance upon subpoena issued by such court or officer. Okay. Section 8, Compelling Attendance. In case of failure, sabi niya, of a witness to attend the court or judge issuing the subpoena, upon proof of the service thereof and of the failure of the witness, pwede raw mag-issue a warrant to the sheriff of the province or his or her deputy to arrest the witness. Nako, pinipwersa ka ng arestuhin ka na, and bring him or her before the court or officer where his or her attendance is required. And the cost of such warrant and seizure of such witness shall be paid by the witness if the court issuing it shall determine that his or her failure to answer the subpoena was willful and without just excuse. So, inaresto ka na, ikaw pa ang magbabayad sa ginastos ng mga officers na nag-aresto sa'yo. Kung ikaw naman ang may kasalanan sa hindi mo pag-attend doon sa hindi mo pagsunod doon nung sinabpina ka, di ka sumipot. Section 9, Contempt. Failure by any person without adequate cause, walang sapat na dahilan, to obey a subpoena served upon him or her shall be deemed a contempt of the court from which the subpoena is issued. If the subpoena was not issued by a court, the disobedience thereto shall be punished in accordance with the applicable law or rule. Diba sa mga kababayan natin? Wow, ano ba yan? Kanina pa nagtatumbling ito napakalikot ko ngayon Sa mga nanonood ng hearing sa Congress, di ba meron sinasabi, iko-contempt ka namin or you will be charged with contempt. Iko-contempt ka, that is a violation of a legal order ng korte. Kung korte ang pinag-uusapan natin or sa Kongreso, yung Kongreso kasi ah binigyan sila ng kapangyarihan ng batas na ipatawag ka. Tapos nagsisinungaling ka ron o hindi ka pupunta, pwede kang i-contempt, pwede kang ipakulong. Depende sa kung anong batas, no? Section 10, Exceptions. The provisions of sections 8 and 9 of this rule shall not apply to a witness who resides more than 100 kilometers from his or her residence to the place where he or she is to testify by the ordinary course of travel or to a detention prisoner if no permission of the court in which his or her case is pending was obtained. Ayun. Medyo makatao naman pala itong rules na to. Sabi niya, yung sinasabi sa provision ng 8 and 9, yung mga contempt, hindi raw yun mag-a-apply sa mga witness na naniniraan 100 kilometers ang layo mula sa lugar kung saan siya mag-testify o sa isang preso kung wala namang pahintulot ang korte na makukuha. Yun ha. So ang ibig niya lang sabihin dito, kunwari, sinabi na yung prisoner ng hindi court ng ibang body, kung hindi sila nakakuha ng permiso mula sa korte, hindi nila siya pwedeng persahin pumunta. Punta naman tayo sa computation of time. Rule 22, how to compute time. Sabi niya, in computing any period of time prescribed or allowed by these rules or by order of the court or by any applicable statute, the day of the act or event from which the designated period of time begins to run is to be excluded. So, hindi kasali. And the date of performance included. If the last day of the period as thus computed falls on a Saturday, a Sunday, or a legal holiday in the place where the court sits, the time shall not run until the next working day. Malinaw naman yun ha. So, kung meron kang 10 days, natanggap mo January 1, ang bilang mo 2, 3, 4, 5, 6, 7, 8, 9, 10. Sa 11, doon ka dapat magpunta. Kung yung 11 o kaya yung 11 is holiday, o kaya Sabado, 12 linggo o 13 next working day, pwede ka pa. Okay? Section 2, effect of interruption. Should an act be done which effectively interrupts the running of the period, the allowable period after such interruption shall start to run on the day after notice of the cessation of the cause thereof. The day of the act that caused the interruption shall be excluded in the computation of the period. Magtungo naman tayo sa Rule 23. Nakikinig ka ba, Pern-Ann? Baka bigla ka maging abogado, Pern-Ann, ha? Huwag mo akong kalimutan. Rule 23, Section 1, Deposition, pending action, when may be taken. Sabi rito, upon ex parte motion of a party, the testimony of any person, whether a party or not, may be taken by deposition upon oral examination or written interrogatories. The attendance of witnesses may be compelled by the use of a subpoena as provided in Rule 21. Deposition shall be taken only in accordance with these rules. The deposition of a person confined in prison may be taken only by leave of court on such terms as the court prescribes. Section 2, Scope of examination. Unless otherwise ordered by the court, as provided by Section 16 or 18 of this rule, the deponent may be examined regarding any matter not privileged which is relevant to the subject of the pending action, whether relating to the claim or defense of any party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of relevant facts. Section 3, Examination and Cross-Examination. Examination and cross-examination of deponents may proceed as permitted at the trial, sabi niya. Sa ibang rule na yon. Section 4, Use of Depositions. Sabi niya rito, at the trial or upon the hearing of a motion or an interlocutory proceeding, any part any part or all of a deposition so far as admissible under the rules of evidence, basta daw nasa rules na admissible siya, may be used against any party who was present or represented at the taking of the deposition or who had due notice thereof in accordance with any one of the following provisions. Basahin natin. A. Any deposition may be used by any party for the purpose of contradicting or impeaching the testimony of the deponent as witness. B. The deposition of a party or of anyone who at the time of taking the deposition was an officer, director, or managing agent of a public or private corporation, partnership, or association which is a party may be used by an adverse party for any purpose. Letter C. The deposition of a witness, whether or not a party may be used by any party for any purpose if the court finds, number 1, that the witness is dead, 2, that the witness resides at a distance more than 100 kilometers from the place of trial or hearing, or is out of the Philippines, number 3, unless it appears that his or her absence was procured by the party offering the deposition, or number 3, and that the witness is unable to attend or testify because of age, sickness, infirmity, or imprisonment, or number 4, that the party offering the deposition has been unable to procure the attendance of the witness by subpoena, or 5, upon applicable and application and notice, that such exceptional circumstances exist as to make it desirable in the interest of justice and with due regard to the importance of presenting the testimony of witnesses orally in open court to allow the deposition to be used. Yun yung mga paggamit ng deposition. At ang huli, yung letter D, if only part of a deposition is offered in evidence by a party, the adverse party may require him or her to introduce all of it which is relevant to the part introduced, and any party may introduce other parts. Ayan ha. Section 5. Ito naman yung epekto ng substitution of parties. Substitution of parties does not affect the right to use depositions previously taken, and when an action has been dismissed and another action involving the same subject is afterward brought between the same parties or their representatives or successors in interest, all depositions lawfully taken and duly filed in the former action may be used in the latter as if originally taken. Therefore, Section 6. Objections to admissibility. Subject to the provisions of Section 29 of this rule. Mamaya pupuntahan natin yun. Objections, tama ba? Objections may be made at the trial or hearing to receiving in evidence any deposition or part thereof for any reason which would require the exclusion of the evidence if the witness were then present and testifying. Section 7. Ano naman epekto of taking depositions? A party shall not be deemed to make a person his or her own witness for any purpose by taking his or her deposition. Nakaangkla po naman yan sa konstitusyon. Constitutional lahat naman ng sinasabi rito. Section 8. Effect of using depositions. The introduction in evidence of the deposition or any part thereof for any purpose other than that of contradicting or impeaching the deponent makes the deponent the witness of the party introducing the deposition, but this shall not apply to the use by an adverse party of a deposition as described in paragraph B of section 4 of this rule. Yan sinabi niya. Rebutting deposition, section 9, o yung kontrahin mo. At the trial or hearing, any party may rebut any relevant evidence contained in a deposition, whether introduced by him or her by any other party. Punta naman tayo sa section 10. Mabalik ako doon. Yung rebuttal, ito yung sa trial na ito. Yung kukontrahin mo, yung sinabi niya, rebuttal yan. Kontrahin mo yung sinaad niya. So, sabi roon, sa trial daw at hearing, any party raw may rebut any relevant evidence na kasi yung evidence, yung testimonya, considered evidence yan. Okay, ino-offer yan as evidence sa korte. Section 10, persons before whom depositions may be taken within the Philippines. Within the Philippines, depositions may be taken before any judge, notary public, or the person referred to in Section 14 hereof. Section 11. Persons before whom depositions may be taken in foreign countries. In a foreign state or country, depositions may be taken A. On notice before a Secretary of Embassy or Legation, Consul General, Consul, Vice Consul, or Consular Agent of the Republic of the Philippines. B. Before such person or officer as may be appointed by commission or under letters rogatory. C. The person referred to in Section 14 hereof. Ayun. Yun yung mga tao ha. Mga matataas na opisyal ito ha. Section 12. Commission or letters rogatory. Paliliwanag niya kasi hindi ko rin naiintindihan to. A commission or letters rogatory shall be issued only when necessary or convenient on application and notice and on such terms and with such direction as are just and appropriate. Officers may be designated in notices or commissions either by name or descriptive title, and letters rogatory may be addressed to the appropriate judicial authority in the foreign country. Sabi niya, yung pagkamit daw, yung commission na a commission or letters rogatory, ini-issue lamang daw yan pagka kailangan. Okay? Yan ang sinasabi niya. Magde-designate ka ng officers. Ang officers may be designated. Tama. I-designate siya ng korte sa pamamagitan ng notices or commissions. Ganun, either by name or descriptive title. At i-address ito to the appropriate judicial authority doon sa foreign country na yun. Di ba? Section 13. Disqualification by interest. No deposition shall be taken before a person who is a relative within the 6th degree of consanguinity or affinity or employee or counsel of any of the parties, or who is a relative within the same degree or employee of such counsel, or who is financially interested in the action. Okay. Section 14. Ito ang disqualification by interest. Sinasabi nilang dito yung conflict of interest, no? Kung kaya't hindi po pwede. Section 14. Stipulations regarding taking of depositions. If the parties so stipulate in writing, depositions may be taken before any person daw authorized to administer oaths at any time or place in accordance with these rules, and when so taken may be used like other depositions. Section 15. Deposition upon oral examination. Notice, time, and place. Okay. A party desiring to take the deposition o yung salaysay ng isang person upon oral examination shall give reasonable notice in writing to every other party to the action. The notice shall state the time and place for taking the deposition and the name and address of each person to be examined kung alam ito, if known, sabi nga rito. At kung yung pangalan ay hindi alam, a general description sufficiency to identify him or her or the particular class or group to which he or she belongs. On motion of any party upon whom the notice is served, the court may, for cause shown, enlarge or shorten the time. Section 16. Orders for the protection of parties and deponents. After notice is served for taking a deposition by oral examination, upon motion seasonably made by any party or by the person to be examined for good cause shown, the court in which the action is pending may make the following orders. Ano ba yung mga pwede niyang gawing pag-uutos? A. That the deposition shall not be taken. B. That the deposition may be taken only at some designated place other than the stated in the notice. C. That the deposition may be taken only on written interrogatories. D. That certain matters shall not be inquired into. E. That the scope of the examination shall be held with no one present except the parties to the action and their officers or counsel. F. That after being sealed, the deposition shall be opened only by order of the court. Letter G. That secret processes, developments, or research need not be disclosed. Okay, hindi pwedeng ipachismis. Or letter H. That the parties shall simultaneously file specified documents or information enclosed in sealed envelopes to be opened as directed by the court. The court may make any other order which justice requires to protect the party or witness from annoyance, embarrassment, or oppression. So, pwedeng protektahan ng korte yung mga witness para hindi sila asarin, ipahiya, or apihin. Section 17, Record of Examination, Oath at Objections. Sabi nga rito, the officer before whom, sandali nga, medyo nangangalay ako. Kanina pa ako. Parang sa ulo ko, no? The officer before whom, balik tayo sa section, ayan, nag-reconnect. And shall personally or by someone acting under his or her direction and in his or her presence record the testimony of the witness. Sabi niya, the testimony shall be taken stenographically unless the parties agree otherwise. All objections made at the time of the examination to the qualifications of the officer taking the deposition or to the manner of taking it or to the evidence presented or to the conduct of any party, and daming chorba, no? And any other objection to the proceedings shall be noted by the officer upon the deposition. Evidence objected to shall be taken subject to the objections. In lieu of participating in the oral examination, parties served with notice of taking a deposition may transmit written interrogatories to the officers who shall propound them to the witness and record the answers. Yan. Ang dami. Section 18. Yeah. Section 18. Motion to terminate or limit examination. At any time during the taking of the deposition, on motion or petition of any party or of the deponent, and upon showing that the examination is being conducted in bad faith or in such manner as unreasonably to annoy, embarrass, or oppress the deponent or party, yung nagsasalaysay, gusto lamang iharas o ipahiya, in which the action is pending, or the RTC of the place where the deposition is being taken, may order the officer conducting the examination to cease, tigilan mo yan, forthwith from taking the deposition, or may limit the scope and manner of the taking of the deposition as provided in Section 16 of this rule. If the order made terminates the examination, it shall be resumed thereafter only upon the order of the court in which the action is pending. Upon demand of the objecting party or the deponent, the taking of the deposition shall be suspended for the time necessary to make a notice for an order, period. In granting or refusing such order, the court may impose upon either party or upon the witness the requirement to pay such costs or expenses as the court may deem reasonable. Okay? Pahaba ng mga batas-batas, ano? Okay. Wait lang, ha? Sandali lamang. Wait lamang. Okay. Hina ng internet. Wala na talaga asenso yata ang internet sa Pilipinas, ano? Okay. Punta naman tayo sa, nasaan na tayo? Section 18 na yan. Section 19. Ito. Submission to witness, changes, and signing. Sige. Yun, kapag daw ang testimonya ay fully transcribed na, the deposition shall be submitted to the witness for examination and shall be read to or by him or her. unless such examination and reading are waived by the witness and by the parties. Any changes in form or substance which the witness desires to make shall be entered upon the deposition by the officer, which as with a statement of the reasons given by the witness for making them. The deposition shall be signed by the witness unless the parties by stipulation waive the signing, or the witness is ill or cannot be found, or refuses to sign. If the deposition is not signed by the witness, the officer shall sign it and state on the record the fact of the waiver or of the illness or absence of the witness, or the fact of the refusal to sign, together with the reason given therefore, kung meron daw man, if any, and the deposition may then be used fully as though signed, unless on a motion to suppress under Section 29 of this rule. Meron daw kasi motion to suppress eh. The court holds that the reasons given for the refusal to sign require rejection of the deposition in whole or in part. 20, Section 20, certification by and filing by officer. The officer shall certify on the deposition that the witness was duly sworn to him or her, and that the deposition is a true record of the testimony given by the witness. He or she shall then securely seal the deposition in an envelope endorsed with the title of the action and marked Deposition of, tapos insert name of witness, and shall promptly file it with the court in which the action is pending, or send it by registered mail to the clerk thereof for filing. Okay. Section 21, notice of filing. Lahat ng mga steps na mga maliliit sa korte, talagang binusisi, binigyan ng rules, Notice of filing. The officer taking the deposition shall give prompt notice of its filing to all the parties. Section 22, furnishing copies. Upon payment of reasonable charges, therefore, the officer shall furnish a copy of the deposition to any party or to the deponent. Okay. Kanina ko pa sinasabing salaysay ang deposition. Para lang sa kaalaman ng lahat, no? Ano nga ba ang eksaktong kahulugan ng deposition? Sige nga. Di ba? Para sure. The process of giving sworn evidence. Sabi sa Tagalog, pagtitiwalag or salaysay. Yan Magbibigay ng statement. Tama nga ako sa aking mga sinasabi. Okay, saan na tayo? Okay. Okay, Section 22, furnishing copies. Basahin ko na lang ulit para okay. Upon payment of reasonable charges, therefore, the officer shall furnish a copy of the deposition to any party or to the deponent. Section 20. Dami, no? May bayad lahat, no? Ang hirap magkaroon ng kaso. Pakahirap, kaya mga kababayan, parang awa nyo na. Dito yung mayaman ng mga abogado. Napakakala mo, simple lang sa kanila to, pero kumbaga may sukat lahat, may sinusundan sila na dapat gawin. Hindi po simple, hindi po ordinaryong makasuhan. Section 23, failure to attend of party giving notice. If the party giving the notice of the taking of a deposition fails to attend and proceed therewith, and another attends in person or by counsel pursuant to the notice, the court may order the party giving the notice to pay such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. Di ba? Failure to attend Section 20, failure of party giving notice to serve subpoena. Hindi ka nakapagbigay ng note to serve subpoena. So if the party giving the notice of the taking of a deposition of a witness fails to serve a subpoena upon him or her, and the witness because of such failure does not attend, And if another part tends in person or by counsel because he or she expects the deposition of that witness to be taken, the court may order the party giving the notice to pay such other party the amount of the reasonable expenses incurred by him or her and his or her counsel in so attending, including reasonable attorney's fees. Yeah. Section 25, sabi niya, deposition upon written interrogatories, notice, and of interrogatories. Party desires, ano ba ang interrogatories? Ano doon? Ano ba to? Ay, puro GR naman yung lumabas. Dali Ang hirap din maghanap sa internet Ito. Ito ang sinabi niya rito. Yun daw, interrogatories, written questions that are sent to the opposing party to answer which a party, ano ba ito, bitin? Written questions. Okay, yun siya. Diba, interrogation, ibig sabihin, tinatanong ka, yung interrogatories, they are written questions that are sent to the opposing party to answer, which a party may answer or object on legal ground. Interrogatories occur pre-trial, wag na natin yan kasi hindi ko alam kung sa pre-trial nga ba yan. Baka may iba tayong rules, pero since parehas naman yata tayo sa Amerika, baka yun din yun. Sige, basta alam niya na yung interrogatories Yan na naman Bakit ba hirap na hirap ako sa upuan ko? Ayan Sabi niya nga kasi, a party desiring to take the deposition of any person upon written interrogatories shall serve them upon every other party with a notice stating the name and address of the person who is to answer them and the name or descriptive title and address of the officer before whom the deposition is to be taken. Sa atin, usually, salaysay lang to Tatawagin ka lang para sa salaysay Within 10 calendar days thereafter, a party so served may serve cross-interrogatories upon the party proposing to take the deposition. Ito, hindi ko na-encounter ito sa korte. Baka na-encounter ko, hindi ko lang alam. Within 5 calendar days thereafter, the latter may serve redirect interrogatories upon a party who has served cross-interrogatories. Within 3 calendar days after being served with redirect interrogatories, a party may serve recross interrogatories upon the party proposing to take the deposition. So kung meron ka sa salaysay, pwede ka nilang padalhan ng mga written interrogatories, sasagutin mo to. Tapos parang kino-cross-examine mo, no? Ano kaya ito, mga bago mga bago to bagong rules. So officers to take responses and prepare record. This is section 26. A copy of the notice and copies of all interrogatories served shall be delivered by the party taking the deposition to the officer designated in the notice, who shall proceed promptly in the manner provided by Section 17, 19, 20 of this rule to take the testimony of the witness in response to the interrogatories and to prepare, certify, and file or mail the deposition, attaching thereto the copy of the notice and the interrogatories received by him or her. Section 27. Ito ang hirap ng unawain mga kapatid. Section 27. Notice of filing and furnishing copies. When a deposition upon interrogatories is filed, the officer taking of reasonable charges thereof. Section 28. Orders for the protection of parties and deponents. Taas naman ito. Bumagsak. Yun. Okay. Saan tayo? Orders for the protection of parties and deponents. After the service of the interrogatories and prior to the taking of the testimony of the deponent, the court in which the action is pending, on motion promptly made by a party or deponent, and for good cause shown may make any order specified in sections 15, 16, and 18 of this rule, which is appropriate and just, or an order that the deposition shall not be taken before the officer designated in the notice, or that it shall not be taken except upon oral examination. Punta naman tayo sa section 29. Basically, ito naman ay order for protection ng mga partido at ng mga magsasalaysay. Section 29, ito, ano naman daw yung epekto ng error and irregularities in decisions. As to notice, in the notice and deposition are waived unless written objects as to disqualification of officer, objection to taking a deposition because of disqualification of the officer before whom it is to be taken is waived unless made before the taking of the deposition begins, or as soon thereafter as the disqualification becomes known or could be discovered with reasonable notice. Sa pagkuha ng deposition o ng salaysay ay waived na. Ibig sabihin ng waived, wala na. Unless meron daw written objection na sinerve upon the party na nagbibigay ng notice. Kunwari, binigyan mo ako ng notice. Meron ako written objection na dapat iserve ko sa'yo. Ganon na merong mali. May irregularidad. Okay, as to disqualification of officer. Yun daw objection to taking a deposition dahil disqualified ang isang opisyal na kumuha ng aking deposition, na aking salaysay, waived daw yun. Unless bago raw ako kuhanan ng salaysay, ipaalam ko na with reasonable diligence na hindi ka kwalipikadong kumuha ng aking salaysay. O letter C, as to competency or relevancy of evidence. Objections to the competency of a witness or the competency, relevancy, or materiality of testimony are not waived by failure to make them before or during the taking of the deposition unless the ground of the objection is one which might have been obviated or removed if presented at that time. Hindi ko yan maintindihan ng isang basa lang. Pero ang sabi niya rito, yung mga objections doon sa competency ng isang witness o yung relevancy o yung materiality ng testimonya niya, ay hindi naman siya waived kapag ikaw ay pag nag-fail ka to make them before or during the taking of the deposition. Unless, sabi niya, the ground of the objection is one which might have been obviated or removed if presented at that time. Ano sabi niya? Letter D, as to oral examination and other particulars. Errors and irregularities occurring at the oral examination in the manner of taking the deposition in the form of the questions or answers in the oath or affirmation, or in the conduct of the parties, and errors of any kind which might be obviated, removed, or cured if promptly prosecuted, are waived unless reasonable objection thereto is made at the taking of the deposition. Dapat kang mag-object, hindi tama. Yun. As to form of written interrogatories. Sabi rito, 26 of this rule are waived unless served in writing upon the party, propounding them within the time allowed for serving succeeding cross or other interrogatories and within 3 calendar days after service of the last interrogatories authorized. Yun. Dapat mag-written objection ka. Ayan. F, kung merong hindi tama. F, as to manner of preparation. Errors and irregularities in the manner in which the testimony is transcribed or the deposition is prepared, signed, certified, sealed, endorsed, transmitted, filed, or otherwise dealt with by the officer under Section 17, 19, 20, and 26 of these rules are waived unless a motion to suppress a deposition or some part thereof is made with reasonable promptness. Yan sabi niya. After such defect is or with due diligence might have been ascertained. Punta naman tayo sa Rule 24. Sus Mario si Pernan, ha? Wala namang manonood nito. Pernan ikaw lang Saka Alain Hindi mo kayo nanonood yata. Ito. Rule 24. Depositions before action or pending appeal. Depositions before action. Petition. Ano ibig sabihin? Hindi ko rin naintindihan. A person who desires to perpetuate his or her own testimony or that of another person regarding any matter na pwede raw kilalanin o cognizable in any court of the Philippines may file a verified petition in the court of the place of the residence of any expected adverse party. Okay? So, pwede ka raw mag-file ng verified petition doon sa korte sa lugar ng residensya nung ina-expect mong kalaban. Saan ba tayo? 24, Rule 24, Section 2. Section 2, Contents of Petition. The petition shall be entitled in the name of the petitioner. Ito yung pag magpe-petition ka. Ito na yung pinag-uusapan natin. Ano yung nakalagay? The petition shall be entitled in the name of the petitioner and shall show, letter A, that the petitioner expects to be a party to an action in a court of the Philippines but is presently unable to bring it or cause it to be brought. Letter B, the subject matter of the expected action and his or her interest therein. Letter C, the facts which he or she desires to establish by the proposed testimony and his or her reasons for desiring to perpetuate it. Letter D, the names or a description of the persons he or she expects will be adverse parties and their addresses so far as known. Ilalagay mo yung pangalan at address ng mga iniisip mong makakalaban mo. And E, the names and addresses of the persons to be examined and the substance of the testimony which he or she expects to elicit from each, and shall ask for an order authorizing the petitioner to take the depositions of the persons to be examined named in the petition for the purpose of perpetuating their testimony. Section 3. Section 3, Rule 24, Notice and Service. Daming mga notice tsaka service, no? Sa subpoena, notice. Summons, notice. Kung ano mga... Ito naman, Section 3, Rule 24 pa rin, Notice and Service. The petitioner shall serve a notice upon each person named in the petition as an expected adverse party. O syempre, na-notify mo yung kalaban mo together with a copy of the petition stating that the petitioner will apply to the court at a time and place named therein for the order described in the petition. At least 20 calendar days before the date of the hearing, the court shall cause notice thereof to be served on the parties and prospective deponents in the manner provided for service of summons. Ganon din yung manner niya kung paano isi-serve yung mga summons. Paano yung manner prescribed in service of summons. Section 4, Order and Examination. Kung ang korte daw ay nasatisfied that the perpetuation of the testimony, yung paglalahad mo ng testimonya mo, may prevent a failure or delay of justice, it shall make an order designating or describing the persons whose deposition may be taken and specifying the subject matter of the examination and whether the depositions shall be taken upon oral examination or written interrogatories. So, magde-decide yung korte kung oral examination ba o written interrogatories. The depositions may then be taken in accordance with Rule 23 before the hearing. Ito, puro before the hearing to. Ano ka pa lang, nagsisik ka pa lang, naghahangad ka pa lang ng remedyo. Section 5, Reference to Court. For the purpose of applying Rule 23 to depositions for perpetuating testimony, each reference therein to the court in which the action is pending shall be deemed to refer to the court in which the petition for such deposition was filed. Ayan ha. Section 6, Use of Deposition. If a deposition to perpetuate testimony is taken under this rule, or if, although not so taken, it would be admissible in evidence, it may be used in any action involving the same subject matter subsequently brought in accordance with the provisions of Sections 4 and 5 of Rule 23. So, pwede mo siyang gamitin daw Kung yung pagkuha naman ng testimonya mo, o kung hindi man ito nakuha, katanggap-tanggap naman. So, rules on evidence, pwede raw itong gamitin sa ibang aksyon na may same subject matter. Sabi niya. Section 7, Depositions pending appeal. If an appeal has been taken from a judgment of a court, including the Court of Appeals in proper cases, or before the taking of an appeal, if the time therefore has not expired, the court in which the judgment was rendered may allow the taking of depositions of witnesses to perpetuate their testimony for use in the event of further proceedings in the said court. In such case, the party who desires to perpetuate the testimony may make a motion in the said court for leave to take the depositions upon the same notice and service thereof as if the action was pending therein. The motion shall state, ito yung nakalagay sa motion, A, the names and addresses of the persons to be examined, the substance, yung sustansya ng iyong testimonya, which he or she expects to elicit from each. Ano ba yung dapat niyang makuha sa'yo? May sense ba yan? B, the reason for perpetuating their testimony. If the court finds that the perpetuation of the testimony is proper to avoid the failure or delay of justice, mahalaga yung testimonya mo para sa hindi matagalan ng hustisya, it may make an order allowing the depositions to be taken, and thereupon the depositions may be taken and used in the same manner and under the same conditions as are prescribed in these rules for depositions taken in pending actions. Daming rules na actually hindi ko pa rin siya lubos na naiintindihan. Ang daming rules sa pagkuha lamang ng salaysay. Sus Maria Josep. Rule 25. Interrogatories to parties. Interrogatories to parties. Section 1. Interrogatories to parties, service thereof. Ayan. Upon ex parte motion, any party raw desiring to elicit, nais mong kumuha ng mahalaga ng material and relevant facts from any adverse parties shall file and serve upon the latter written interrogatories to be answered by the party served, or if the party served is a public or private corporation or a partnership or association, by any officer thereof competent to testify on its behalf. Section 2. Answer to interrogatories. The interrogatories shall be answered fully in writing and shall be signed and sworn by the person making them. Sabi niya. O yun lang naman, sinasabi niya, signed and sworn. Di ba? Nakalagay naman yan sa lahat ng mga salaysay. The party upon whom the interrogatories have been served shall file and serve a copy of the answers on the party submitting the interrogatories within 15 calendar days after service thereof, unless the court on motion and for good cause shown extends or shortens time. Section 3. Ano yung sinasabi? Basahin na naman natin. Puro basa lamang tayo. Hindi ko na maipaliwanag eh. Section 3. Objections to interrogatories. Sabi rito, objections to any interrogatories may be presented to the court within 10 calendar days after service thereof, with notice and as in case of a motion. Para rin daw kang nag-file ng motion. Kung meron kang objection dun sa interrogatory, nag-object ka, ipe-present mo rin siya sa court within 10 calendar days matapos mo matanggap yung interrogatory na kung saan ka nag-object. Ibigyan mo rin siya ng notice, similar sa isang motion. And answers shall be deferred until the objections are resolved, which shall be at as early a time as is practicable. Siyempre, the earlier the better. Yan naman lagi eh. Section 4, number of interrogatories. No party may, without leave of court, serve more than one set of interrogatories to be answered by the same party. So, kailangan kung magbibigay ka ng higit pa sa isang set ng iyong written interrogatories, kailangan mo mag-motion for leave of court. Grabe ka naman, napakarami mong written questions. Section 5, scope and use of interrogatories. Interrogatories may relate to any matters that can be inquired into under Section 2 of Rule 23, and the answers may be used for the same purposes provided in Section 4 of the same rule. Section 6, ano naman daw ang epekto ng failure to serve written interrogatories? Ito gusto ko itong malaman kasi parang yung mga Yan ba yan? Sabi niya rito, unless thereafter allowed by the court for good cause shown and to prevent a failure of justice, a party not served with written interrogatories may not be compelled by the adverse party to give testimony in open court or to give a deposition pending appeal. So mahalaga pala to kasi kapag daw hindi ka pinayagan ng korte, 'di ba? Yung isang partido na hindi nag-serve ng written interrogatories ay hindi maaaring pilitin nung kabilang partido na magbigay ng testimonya in open court or to give a deposition o ng salaysay during the pendency of an appeal. Okay? Maya-maya tutungo na tayo sa Rule 26. Bakit? Maganda yan, ma-inspire siya. May bago na ako ngayon. Batas. Okay, game. Punta naman tayo sa Rule 26, Admission by Adverse Party. Ay, sige. Ay, haba, no? Bawat live ko, iilang pirasong rules o provision sa batas, oras ang inaabot. Diba? Iniisip ko na lang, dahil man ako masyadong kausap, so eto na yung pangangailangan ko magsalita. Okay, Rule 26. Admission by adverse party. Section 1. Request for admission. Sabi niya, at any time after issues have been joined, a party may file and serve upon any other party a written request for the admission by the latter of the genuineness of any material and relevant document described in and exhibited with the request, or of the truth of any material and relevant matter of fact set forth in the request. So usually magre-request ka lang, tapos sasabihin mo, I admit as to the genuineness and the truthfulness of this document. Nakalagay yan doon sa pagka nakakita kayo ng sa korte, ganun. Ano pa ba? Copies of the documents shall be delivered with the request unless copies have already been furnished. Section 2, Implied Admission. Each of the matters of which an admission is requested shall be deemed admitted unless within a period designated in the request, which shall not be less than 15 calendar days after service thereof, or within such further times the court may allow on motion, the party to whom the request is directed files and serves upon the party requesting the admission of a sworn statement, either denying specifically the matters of which an admission is requested or setting forth in detail the reasons why he or she cannot truthfully either admit or deny those matters. I neither admit nor deny. Yung mga ganun lang yan eh. Objections to any request for admission shall be submitted to the court by the party requested within the period for and prior to the filing of his or her sworn statement as contemplated in the preceding paragraph, and his or her compliance therewith shall be deferred until such objections are resolved, which resolution shall be made as early as practicable. Pakinggan mo na lang ulit at unawain. Hindi ko rin maintindihan eh. Section 3, ano bang epekto ng admission o yung tinanggap mo, yung ano niya? Oo na. Any admission made by a party pursuant to such request is for the purpose of the pending action only and shall not constitute an admission by him or her for any purpose. Kumbaga para sa ano lang daw yon, para dun sa ina-admit mo lang na okay yung dokumento. Hindi naman ibig sabihin ina-admit mo na ikaw yung nagnakaw ng lupa o siya nga may mas karapatan sa lupa. Hindi ganun. Ina-admit mo lang yung katotohanan dun sa dokumento. Section 4, withdrawal. Hindi po ito yung withdrawal na para hindi ka makabuntis. Ha? The court may allow the party making an admission under this rule, whether express or implied, to withdraw or amend it upon such terms as may be just. Okay? Sabi niya, no? Oh, malinaw lang naman yun. Pwede raw i-allow ng court yung isang partido na nagbibigay ng admission, whether express or implied, to withdraw or amend, baguhin yung ibang mga nakalagay doon. Basta ito ay alinsunod sa hustisya. Pwede naman eh. Pwede naman po. Section 5, effect of failure to file and serve request for admission. Hindi ko na ano yung sinasabi ko, hindi ko na naintindihan. Effect of failure to file and serve request for admission. Unless otherwise allowed by the court for good cause shown and to prevent the failure of justice, a party who fails to file and serve a request for admission on the adverse party of material and relevant facts at issue which are or ought to be within the personal knowledge of the latter shall not be permitted to present evidence on such facts. So hindi ka papayagan magpresenta ng iyong ebidensya kung ikaw ay hindi nakapag-file and serve request for admission. So ito siguro yung parang notice sa korte. Sa madaling salita, ito yung notice sa korte na tanggapin na i-admit ang iyong mga ebidensya. Oh. Yun siguro yun. Okay. Actually, ganun lang yun. Bibigay ka ng notice na tanggapin ang iyong mga ebidensya. Rule 27. Malapit na tayo sa Rule 30. Production or inspection of documents or things. Sabi niya lang dito, motion for production or inspection. Yun yung ginagawa ng abogado. I would like to file a motion for production or inspection. Tapos maglalabas ng order yung korte. Basahin natin. Upon motion of any party showing good cause, therefore, the court in which an action is pending may. Pwede raw mag-order yung court. Ulitin natin. Yung korte daw may, letter A, order any party to produce and permit the inspection and copying or photographing by or on behalf of the moving party of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things not privileged, which constitute or contain evidence material to any matter involving the action and which are in his or her possession, custody, or control. Pwede yung utusan yung isang partido na, pagbigyan mo itong moving party na kailangan niya ng copy ng mga ebidensya mo. Or B, order any party to permit entry upon designated land or other property. Yan, kadalasan sa civil cases. Civil procedure tayo so civil cases, mga problema sa lupa. Ipe-permit nila yung isang partido entry upon designated land or other property in his or her possession or control for the purpose of inspecting, measuring, surveying, or photographing the property or any designated relevant object or operation thereon. The order shall specify the time, place, and manner of making the inspection and taking copies and photographs, and may prescribe such terms and conditions as are just. Okay? Rule 28. Naku, sana naman hindi mahaba to. Hindi siya mahaba. Rule 28, physical and mental examination of persons. Ito ha. Section 1, kailan daw ba pwedeng i-order ang examination? In an action in which the mental or physical condition of a party is in controversy, the court in which the action is pending may in its discretion order him or her to submit to a physical or mental examination by a physician. Section 2, order for examination. The order for examination may be made only on motion for good cause shown and upon notice to the party to be examined and to all other parties, and shall specify the time, place, manner, conditions, and scope of the examination and the persons or persons by whom it is to be made. Okay. Subukan ko nga yung hindi yung mukha ko yung nakikita. Kaya lang baka mahilo naman pagka kung nakaganyan. Yan, para nakikita nyo yung binabasa ko. Labay, ayan. Report of findings. if requested by the party examined, the party causing the examiner to deliver to him or her a copy of a detail of the examining physician. Kailangan ipakita ko nila yung mukha ko. Kailangan mong, hindi nyo rin mababasa no? Kung gusto nyo no? Hindi nyo rin, mahirap din basahin yung binabasa ko So, anyway, binabasa ko lang naman nasa supremecourt.gov.ph po ito. So sabi niya rito, balikan natin Section 3, Report of Findings. If requested by the party examined, the party causing the examination to be made shall deliver to him or her a copy of a detailed written report of the examining physician setting out his or her findings and conclusions. After such request and delivery, period muna yung conclusions. After such request and delivery, the party causing the examination to be made shall be entitled upon request to receive from the party examined a like report of any examination previously or thereafter made of the same mental or physical condition. If the party examined refuses to deliver such report, the court on motion and notice may make an order requiring delivery on such terms as are just. At kapag daw yung doktor fails or refuses to make such report, the court may exclude his or her testimony if offered at the trial. So, ayaw mong gumawa ng report, hindi ka pwedeng tumestigo sa trial. Hindi pa pwedeng kilalanin yung testimonya mo. Section 4, Waiver of Privilege. By requesting and obtaining a report of the examination so ordered or by taking the deposition of the examiner, the party examined waives any privilege he or she may have in that action or any other involving the same controversy regarding the testimony of every other person who has examined or may thereafter examine him or her in respect of the same mental or physical examination. Okay, meron ding waiver of privilege. Na tayo sa 29. Ay, okay. Naku, susmeyo, ang 30 is about trial. Ang haba, ang dami. Ay, hindi naman masyado. Sige, basta tapusin na natin. 29. Rule 29, refusal to comply with modes of discovery. Okay. So, Section 1, refusal to answer. Kapag daw ang isang partido or other deponent, yung mga nagsasalaysay, refuses to answer any question upon oral examination, the examination may be completed on other matters or adjourned or tatapusin ito as the proponent of the question may prefer. The proponent may thereafter apply to the proper court of the place where the deposition is being taken for an order to compel an answer. Yung proponent, yung nagtatanong, yun ang kailangan ng sagot, pwede siya mag-apply ng order sa korte para pilitin yung tao na sumagot. The same procedure may be availed of when a party or a witness refuses to answer any interrogatory submitted under Rules 23 or 25. Pag ayaw niya sumagot sa written interrogatories, yung nabasa natin kanina, pwede siyang i-compel ng korte na sumagot. Kasi nga po, parang may mga bagong rules na ngayon, puro dokumento na lang. Mayroon na nga written interrogatories Sagot-sagutan tayo. So, kailangan mo sumagot. Paano uusad yung kaso? If the application is granted, the court shall require the refusing party or deponent to answer the question or interrogatory, and if it also finds that the refusal to answer was without substantial justification, ayaw mo lang, it may require the refusing party or deponent or the counsel advising the refusal or both of them to pay. Babayaran ninyo ngayon yung proponent the amount of the reasonable expenses incurred in obtaining the order, including attorney's fees. Tinatanong kayo ayaw nyo sumagot. Meron nga tayong kontrobersiya dito. Tapos tinatanong ka, ayaw mo sumagot. Ano naman kasing klase yun? Paano ma-resolve yung kontrobersiya? Di ba? If the application is denied and the court finds that it was filed without substantial justification, yun daw korte may require the proponent or the counsel advising, nabasa ko na yan, babayaran mo yung attorney's fees nila. Section 2, Contempt of Court. If a party or other witnesses refuses to be sworn, ayaw nyo manumpa, ayaw nyo sumagot, refuses to answer any question after being directed to do so by the court, of the place in which the deposition is being taken, yung refusal mo may be considered a contempt of court. Ano pa ba yung ibang consequences ng hindi mo pagsagot? If any party or an officer or managing agent of a party refuses to obey an order made under Section 1 of this rule na nire-require siya to answer designated questions or an order under Rule 27 na mag-produce ka ng document para inspeksyonin, i-photograph, kailangan makita ng kabilang partido mo, eto yung mga pwede mong kaharapin na parusa. A. An order that the matters regarding which the questions were asked or the character or description of the thing or land or the contents of the paper or the physical or mental condition of the party or any other designated facts shall be taken to be established for the purpose of the action in accordance with the claim of the party obtaining the order. Kukunin namin yan at gagamitin namin in favor of yung hindi mo pinagbigyan. Letter B. An order refusing to allow the disobedient party to support or oppose designated claims or defenses or prohibiting him or her from introducing in evidence designated documents or things or items of testimony or from introducing evidence of physical or mental condition. Hindi ka napapayagan. Makulit ka disobedient party ka Hindi mo nasusuportahan yung claims mo. Maglalabas din ng korte ng order striking out the pleadings or parts thereof or staying further proceedings until the order is obeyed or dismissing the action or proceeding or any part thereof or rendering a judgment by default against a disobedient party. Basta hindi pabor sa disobedient, sa hindi masunurin na partido. Kunwari mayabang yung kliyente. Dapat po kayo kasi ang susunod sa abogado. And letter D. In lieu of any of the foregoing orders or in addition thereto, an order directing the arrest of any party or agent of a party for disobeying any of such orders except an order to submit to a physical or mental examination. Di ba? Arestuhin ka pa. Ayaw mo sumunod Section 4. Expenses on refusal to admit. Kapag daw ang isang party after being served with a request under Rule 26 to admit the genuineness of any document, sinapa-admit sa'yo, tiyatanggap mo ba na genuine ang dokumento nito or the truth of any matter of fact serves a sworn denial thereof, and if the party requesting the admissions thereafter proves the genuineness of such document or the truth of any such matter of fact, he or she may apply to the court for an order requiring the other party to pay him or her the reasonable expenses incurred in making such proof, including reasonable attorney's fees. Unless the court finds that there were good reasons for denial or that admissions sought were of no substantial importance, such order shall be issued. Section 5. Failure of party to attend or serve answers. If a party or an officer or managing agent of a party willfully fails to appear before the officer who is to take his or her deposition after being served with a proper notice, or fails to serve answers to interrogatories submitted under Rule 25 after proper service of such interrogatories, the court on motion and notice may strike out all or any part of any pleading of that party or dismiss the action. O kung ikaw yung ikaw yung naghihingi ng remedyo, dismiss, di patay ka. Dismiss the action or proceeding or any part thereof or enter a judgment by default against that party and in its discretion order him or her to pay reasonable expenses incurred by the other, including attorney's fees. Bayaran mo na yung gastos niya, pati yung attorney's fees. Section 6. Expenses against the Republic of the Philippines. Expenses and attorney's fees are not to be imposed upon the Republic of the Philippines under this rule. Hindi mo pwedeng singilin ang Republic of the Philippines. Rule 30. Trial. Okay. Andito na tayo sa trial. Sus Mariose, mahaba rin to. Section 1. Schedule of trial. The parties shall strictly observe the scheduled hearings as agreed upon and set forth in the pre-trial order. Bago na ito. strictly observe the scheduled hearings. Ganun na daw. Hindi na pwede susugal-sugal ka tapos hindi ka susunod dun sa sinabi dun sa pre-trial order. Kasi order yan eh. After ng pre-trial, naglabas na ng order yung korte na ito yung schedule eh. Sundin mo. Letter A, the schedule of the trial dates for both plaintiff and defendant shall be continuous and within the following grounds. Within the following periods. So, ito yung mga periods. Number 1, the initial presentation of plaintiff's evidence shall be set no later than 30 calendar days after the termination of the pre-trial conference. Plaintiff shall be allowed to present its evidence within a period of 3 months or 90 calendar days, which shall include the date of the judicial dispute resolution if necessary. O, pinabibilis nila yung kaso ngayon, which is very good. Number 2, the initial presentation of defendant's evidence shall be set not later than 30 calendar days after the court's ruling on plaintiff's formal offer of evidence. The defendant shall be allowed to present its evidence within a period of 3 months or 90 calendar days. Pangatlo, the period for the presentation of evidence on the third, fourth, etc. party claim, counterclaim, or cross-claim shall be determined by the court, the total of which shall in no case exceed 90 days. And yung ikaapat, if deemed necessary though, the court shall set the presentation of the parties' respective rebuttal evidence which shall be completed within a period of 30 calendar days. Mas mabilis na ngayon. Okay? So, letter B naman. Ano ba yung letter B na ito? Ito yung basta letter B siya. The trial dates shall be shortened depending on the number of witnesses to be presented, provided that the presentation of evidence of all parties shall be terminated within a period of 10 months or 300 calendar days. So, sabihin na natin isang taon, tapos na yung 300 calendar days. Tapos na isang civil case, sabi. If there are no third, fourth, etc. party claim, counterclaim, or cross-claim, the presentation of evidence shall be terminated within a period of 6 months or 180 days. 180 calendar days. Ganun na ngayon para malinaw. Okay. The court shall decide and serve copies of its decision to the parties within a period not exceeding 90 calendar days from the submission of the case for resolution with or without memoranda. Section 2. Adjournments and postponements. Yun daw, korte may adjourn a trial from day to day and to any stated time as the expeditious and convenient transaction of business may require, but shall have no power to adjourn a trial for a longer period than 1 month for each adjournment, nor more than 3 months in all, except when authorized in writing by the court administrator, Supreme Court. So, ano na yan? Korte na yan. Pero at least may idea tayo. The party who caused postponement is warned that the presentation of its evidence must still be terminated on the remaining dates previously agreed upon. O basta ngayon, kung ano yung dates na agreed upon doon sa pre-trial, kailangan matapos doon yung iyong matapos doon yung iyong presentation of evidence. Presentation of evidence po yung tawag sa paghaharap ng witness, dokumento, yung proseso na yon. Tapos sasagot naman, maghaharap presentation ng witness naman ng defendant. Ang tawag po doon yung presentation of evidence. So kailangan daw matapos yun doon sa dates agreed upon doon sa pre-trial. Okay, section 3. Sabi rito, requisites of motion to postponement of trial for absence of evidence. Wala na yun sa rules of court. So, basahin na natin yung bagong section 3. Requisites of motion to postpone trial for illness of party or counsel. Ito, mas mainam kasi ito. Kasi totoong nangyayari ito. Okay. A motion to postpone a trial on the ground of illness of a party or counsel may be granted if it appears upon affidavit or sworn certification that the presence of such party or counsel at the trial is indispensable and that the character of his or her illness is such as to render his or her non-attendance excusable. Minsan nasa discretion din naman to ng huwes. Minsan may mga masakit yung ulo ko. Sasabihin mo masakit na yung ulo, hindi na maka-attend. Po siya, masakit yung ulo niya kung mag-collapse siya o kaya nahihilo siya. Ano yun nasa sa judge din kung paano kanya tatanggapin. Kasi sakit yung ulo ko. Talagang hindi mo kayang gumalaw ako. Nararanasan ko yung ganong sakit ng ulo. So, ayun. Section 4, hearing days and calendar call. Trial shall be held from Monday to Thursday, and courts shall call the cases at exactly 8:30 a.m. Maaga na ha, and 2 p.m. So magsisimula ang hearing 8:30 a.m. Yan ay ibig sabihin. Tapos break, tapos 2 p.m. ulit. Pursuant to Administrative Circular number 3-99. Hearing on motions shall be held on Fridays pursuant to Section 8 Rule 15. So lahat ng para dinggin yung mga motion mo tuwing Biyernes na lang yun. All courts shall ensure the posting of their court calendars outside their courtrooms. Nakalagay naman po dyan at least 1 day before the scheduled hearings pursuant to OCA Circular number 250-2015. Tumatapos to. Section 5, Order of Pre-Trial. Ito na. Subject to the provisions of Section 2 of Rule 31 and unless the court for special reasons otherwise directs, yun daw trial shall be limited to the issues stated in the pre-trial order and shall proceed as follows. Ito. Dahil civil case to, lilinawin ko lang, kaya walang akusado, yung more on yung plaintiff. Plaintiff yung... Okay. A. Siya naman ang mag-a-adduce o magpapresenta ng ebidensya niya of his or her defense, counterclaim, cross-claim, and fourth-party complaint. The fourth party and so forth, kung meron man, sila naman ang susunod. They shall adduce evidence of material facts pleaded by them. Letter E. The parties against whom any counterclaim or cross-claim has been pleaded shall adduce evidence in support of their defense. So, ito, pati yung mga counterclaim, cross-claim, wala nang separate na, hindi na yan dinidinig. Hindi na yan dinidinig sa separate na araw. Doon sa presentation ng evidence, doon mo na rin pinipresenta yung mga counterclaim or cross-claim. So, yun. Letter F. The parties may then respectively adduce rebutting evidence only unless the court for good reasons and in furtherance of justice permits them to adduce evidence upon their original case. Letter G. Upon admission of the evidence, the case shall be deemed submitted for decision unless the court directs the parties to argue or submit their respective memoranda. O sige, hindi pa ako contento, submit pa kayo ng memoranda or further pleadings. Usually, pinapaganon lang ng korte para i-summarize nyo. Yan na lang yung babasahin ko. Dami yung sinabi. If several defendants or third-party defendants and so forth having separate defenses appear by different counsel, the court shall determine the relative order of presentation of their evidence. Section 6, Oral Offer of Exhibits. Ito sa mga abogado to, i-offer nila sa korte yung exhibits orally. I offer ganito. Yun, ganyan yan. The offer of evidence, the comment or objection thereto, and the court ruling shall be made orally in accordance with sections 34 to 40 of Rule 132. So, ganun na sila mag-offer ng evidence. Ngayon, orally na daw. Okay. Section 7. So, pagkatapos, yung pinirmahan nyo, yung pinag-usapan nyo sa pre-trial, na ito po yung mga ebidensya ko na ipapasok ko sa korte during trial na after mong matapos ipresenta yung, I formally offer the exhibit ganito, the testimony of my client, of the witness, Pedro. Ganon. Ganon na siya ngayon. Okay. Tapos, nasa na? Section 7. Agreed statement of facts. The parties to any action may agree in writing upon the facts involved in the litigation and submit the case for judgment on the facts agreed upon without the introduction of evidence. If the parties agree only on some of the facts in issue, the trial shall be held as to the disputed facts in such order as the court shall prescribe. Tinanggal na raw yung statement of the judge, section 7 yun. Punta na tayo sa section 8. Suspension of actions. The suspension of actions shall be governed by the provisions of the Civil Code and other laws. So, nilagay nila yung other laws para linawin yung mga special laws. Siguro yan, hindi lamang ng Civil Code. Section 9. Judge to receive evidence delegation to clerk of court. The judge of the court where the case is pending shall personally receive the evidence to be adjusted by the parties. Oh, personally niya nang marireceive kasi nga orally in-offer yung evidence. However, in default of ex parte hearings, and in any case where the parties agree in writing, the court may delegate the reception of evidence to its clerk of court. Yung mga ex parte, yung mga hindi naman kailangan dinggin, pwede ka na sa clerk of court who is a member of the bar. Kasi po yung mga korte, RTC, pataas, members of the bar, o mga abogado na yung mga clerk of court dyan. The clerk of court shall have no power to rule on objections to any question or to admission of exhibits, which objections shall be resolved by the court upon submission of his or her report and the transcripts within 10 calendar days from termination of the hearing. At doon po nagtatapos ang rule, ano ba yan? Nakakalimutan ko na kagad. Nakakalimutan talaga ako. Doon po nagtatapos ang rule 21 to 30. Sana pa may natutunan kayo. Muli, ito na naman si Lolo Ray. Pinapaliwanag natin ang civil procedure. Nasa rule 21 to 30 tayo. Pinaliliwanag natin ang batas in layman's terms. So see you sa susunod. Marami pa akong babasahin at susubukang ipaliwanag. At sa mga hindi nyo po naintindihan, sana po ay i-playback nyo na lang. Lalo na ikaw, Pernaan, huwag mo na akong tanungin kung ano man ang aking mga in-explain dito. At ikaw, Alain, ano mo na lang, playback mo na lang. Okay? So, thank you very much sa iyong pagsuporta. Have a pleasant night.